A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here to express my views on my topic virtual courtrooms and access to justice during the coronavirus pandemic. This video is part 2, and in the part 1 video, we understood that COVID 19 is a deadly virus which has originated from the People's Republic of China. Further, we understood that how the coronavirus has brought the entire world to a halt and how it has affected the delivery of justice system. As due to the lockdowns and due to the important mandate of social distancing, it is impossible for the courts to function in normality, and that is why the courts have shifted to virtual conferencing system. The Indian Supreme Court as well has shifted to the virtual conferencing system where all the important matters and matters of daily importance are heard by the Supreme Court and other courts through video conferencing. Later, in the later part of the previous video, we understood how virtual video conferencing is not against Article 145, Clause 4 of the Constitution of India and Section 327 of the Code of Criminal Procedure. Now, in this particular video, we shall be talking about some of Supreme Court cases which have delivered justice through virtual courts only. The very first case that we shall be talking about is Messrs. LG Polymers India Private Limited versus the state of Andhra Pradesh. The facts of this particular case are that in the wee hours of 7th May 2020, reports started coming in that styrene, a hazardous gas, has leaked from a chemical factory in R.R. Venkatpuram village, Vishakhapatnam. This resulted in the death of 11 persons and hospitalization of more than 100 people. More than 1,000 people were reported sick. There was also damage to environment and habitat. The factory from which the gas leaked belonged to LG Polymers. The petitioners further moved to Supreme Court against the order passed by the National Green Tribunal. A three-member bench of A.K. Goyal, chairperson, and Shrio Kumar Singh, judicial member, and Dr. Nagenanda, executive member, held that it was well within NGT's jurisdiction to pass the earlier order dated 8 May 2020, wherein it had directed LG Polymers Private Limited to forthwith deposit an initial amount of 50 crores with the district magistrate, Vishakhapatnam. By the instant order, the NGT gave further directions, which are summarized as: number one, the amount of 50 crores deposited by LG Polymers with the district magistrate will stand appropriated towards part liability and interim compensation to be spent for restoration of environment and compensation for victims in accordance with the restoration plan to be prepared. Number two, the restoration plan may be prepared by a committee comprising of two representatives, each of Ministry of Environment, Forest and Climate Change and Central Pollution Control Board. The next case is Dr. Arushi Jain versus Union of India. The facts of this particular case are that Dr. Arushi Jain, in a petition filed through advocates Mithul Jain and Arjun Syan, had alleged that frontline healthcare workers who were engaged in the fight against COVID-19 are not being paid salaries or their wages are being cut or delayed. Doctors on COVID-19 duty are not provided accommodation near the hospitals, and their friends or family are exposed to higher risk of infection. The petitioner said that the doctors and other healthcare workers who are engaged in the COVID duty run at a great risk of exposure of infection without the proper PPE kits and without proper accommodation. Their family members are also at higher risk of infection. What was held in this particular case was a three-judge bench of Ashok Bhushan, S.K. Kaul, and M.R. Shah issued directions to states for payment of salaries and provide necessary quarantine facilities to the doctors and healthcare workers who are engaged in treating COVID-19 patients. The court further stated that courts should not be involved in the issue of non-payment of salary to healthcare workers and government should settle the issue. On April 8, the court observed that the doctors and the medical staff are the first line of defense of the country in the battle against the COVID-19 pandemic and directed the center to ensure appropriate PPE kits are made available to them for treating the COVID-19 pandemic. The third case that we shall be talking about is Odisha Vikas Parishad versus Union of India. In one of the present applications in this case, an affidavit filed on the behalf of state of Odisha stated that it might be possible to conduct the Rath Yatra at Puri in a limited way without public attendance. This was proposed by Gajpati Maharaj of Puri, who is the chairman of Puri Jagannath Temple Administration. Indeed, if possible to ensure that there is no public attendance, the court said that uh, the court felt that there was no reason why the Rath Yatra cannot be conducted safely along its usual route from temple to temple. The court therefore issued the following directions. Number one, all entry points into the city of Puri, airport, railway, bus stand, etc., shall be closed during the period of the Yatra festival. Number two, the state government shall impose a curfew in the city of Puri on all days and during at all time when the Yatra chariots are taken in procession. Number three, each rath, that is the chariot, shall be pulled by not more than 500 persons. Each of those 500 persons shall be tested for the COVID. They shall be permitted to pull the chariot only if they have been found negative. There shall be an interval of 1 hour between two chariots. Each of those who is engaged in pulling the chariot shall maintain social distancing before, during, and after the Rath Yatra. The last case that we shall be talking about is reference problems and miseries of migrant laborers. In reference problems and miseries of migrant laborers, three-judge bench of Ashok Bhushan, S.K. Kaul and M.R. Shah has directed all the states and union territories to take all necessary steps regarding identification of stranded migrant workers in the state who are willing to return to their native places and take steps for their return journey by train bus, which process may be completed within a period of 15 days. The Supreme Court issued the following guidelines. In the event of any additional demand, in addition to demand of 171 Shramik trains, as noticed above, Railway shall provide Shramik trains within a period of 24 hours. The central government may give details of all schemes which can be availed by the migrant workers who have returned to their native places. All states and union territories shall give details of all schemes which are current in the state, benefit of which can be taken by the migrant laborers, including different schemes for providing employment. Thank you so much.